So unmarried couples can now inherit from one another. The Legal Resources Centre has welcomed a ruling by the Western Cape High Court that's declared heterosexual partners are now eligible to do so. The applicant in the matter was a woman whose life partner passed away without a will. Let's speak now to the Legal Resources Centre's candidate attorney, Amy-Leigh Payne, who's joining us by Skype. Amy-Leigh, good to have you on the program. Let's start first with why it is that unmarried couples were unable to do this in the past.
Good evening. So in the past, the Interstate Succession Act did not allow for permanent opposite-sex life partners to inherit, but it did allow for same-sex life partners to inherit as well as married couples, but it did not allow for opposite-sex life partners in terms of the Interstate Succession Act.
And why was that? Because if there was provision for same-sex, why was the issue different for heterosexual relationships?
So the case for same-sex came up in the Volks judgment, which was decided a few years ago before the Civil Unions Act was passed. The judgment then allowed for same-sex couples to inherit, and because it was specifically a case brought for same-sex couples, it didn't make provision for life partners which are opposite sex. And that was where the applicant in the matter had found herself, that she was in an opposite sex life partnership and the Act did not provide for her.
But now I would imagine the hurdle then becomes for the partners who wish to claim from inheritance becomes what the law would regard as a permanent relationship that therefore qualifies for access to the inheritance. How clear are the lines on that?
So the lines are, they are quite clear on it. The court looks at, was there a reciprocal duty to support the partner, and that was the deciding factor in the Buanya matter as well, where the judge looked at whether there was a reciprocal duty, and she found that there was, and that the life partner who had passed away was therefore supporting Ms. Buanya. And they then had found that there is a life partnership. So that was not quite a big hurdle to pass. The hurdle was, in fact, the fact that when she put claim to the master's office, when the estate was registered, was that she was not then considered as a spouse. And that then became the hurdle.
This now goes to the Constitutional Court for confirmation. Do people benefit immediately, or does the con-court process have to conclude first?
So the judgment by Acting Judge Magona specifically states that it first needs to be confirmed at the Constitutional Court, and it will then apply from the date that the Constitutional Court confirms it. So it will not have retrospective effect, as that would then affect properties that have already been transferred where estates have been finalized. So it will apply once the Constitutional Court confirms it.
Right, Amy-Leigh Payne, candidate attorney with the Legal Resources Centre. Good to speak to you.